The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Everyone, you may be seated. We are here this afternoon for 3 separate cases. The case of Mangwasser versus Comito will be submitted without oral argument at this time. And then we have 2 oral arguments today. The first one is State of Iowa versus McCalley. Ms. Lucey, you may begin.
Good afternoon. May it please the court. I am Martha Lucey. That is Martha Bozen. We will probably both answer to Martha. That's my Martha joke for the day. I am here for the 3rd term in a row talking about Chapter 910, Iowa's recoupment statute, or part of Iowa's recoupment statute. 815.9 is the other portion that is relevant in this analysis. This case presents a lot of interrelated and, to me, interesting issues about what Chapter 910 as far as Category B restitution is and what it means. Is restitution, especially Category B restitution, a part of the criminal sentence? We submit that yes, it is. It increases punishment. Which is the next interrelated question. Is it punishment? Is restitution punishment? Is it penal? We submit the answer is yes. It is part of punishment.
Ms. Lucey, that the amended statute, we'll talk about that one first, doesn't change the amount of the restitution, just the procedure.
It does not necessarily change the amount that court costs may be or what attorney fees may be charged. It does oftentimes change the amount that the defendant will be required to pay because it changes the procedure. So it does.
How so?
It does change the amount that the defendant may be required to pay because of that change in procedure.
Change in the shift in the burden of proof?
Burden of proof, there is the presumption. There is the inability for any type of look back in certain cases that if the amount is not determined at the time that this judgment is enforceable, there may not be any opportunity for remission or reduction. Ms. McCalley was not placed on probation. She doesn't qualify for a 910.7 hearing. That makes a big difference. Federal cases talk about the ability at any time to seek remission if the defendant does not have the ability to pay that restitution. That's what makes the statute constitutional. That's what Iowa has said for years and years and years. That is what every other state that I have found says. I have not found one state that has the procedure that Iowa does.
At any moment, even prior to the 2020 changes, wasn't it the case that after a certain period of time, all you could do is try and change your payment plan? I mean, when how much you would have to pay a month, you couldn't contest the overall amount.
Off probation, parole, or incarceration. But the difference is that under the 2019, let's just call it the 2019 statute, and under this court's precedent, which is Albright and Davis are the other 2 cases that I've been in the last 2 years, that requirement for enforcement, prior to enforcement, the determination had to be made. And here, the court no longer has any obligation to make a determination of the ability to pay unless the defendant requests it. And in Iowa, this judgment is immediately enforceable.
Timing of this is important to talk about. The offense happened in January of 20. The new statute, I call them the old and the new. The new statute, the amended statute, was effective June of 20, so about 6 months later. A month after that, there was a supervisory order regarding how to handle that new statute. And then at about Christmas time, about a year ago right now, the defendant was sentenced. And if I remember right, the plea she signed had all the right language for the new statute, and which included all of those opportunities to request the hearing and all that business. So is this maybe an ineffective assistance case?
I would submit no. I think there's an open question whether Ms. McCalley or someone like her could claim in a PCR ineffective assistance regarding restitution. 822.2 purports to preclude having restitution issues raised in PCR. I would tell you that arguably that 822 point, I think it's 1A, or maybe it's just A, that says that sentences in violation of the Constitution, maybe it would fit in there. Justice, now I'm drawing a blank on who wrote Trout. And I think it was Justice McDonald. You indicated that there is a separate claim of ineffective assistance. So if that's a standalone claim, maybe you can raise it in PCR. But this court has said you can't. But again, if we go back to, is this an ineffective claim, or is the statute constitutionally defective? And if she was advised of something that is more onerous than what she really is subjected to, I think oftentimes the court would find that there's not harm there.
The statute properly before us. My understanding from the sentencing hearing is that the judge did make a finding of reasonable ability to pay based in part on the fact that your client had 2 part-time jobs. Am I misremembering that?
Correct. The judge did find the ability to pay, but that was because the new statute required the judge to presume that she had the ability to pay, even though all the rest of the sentencing hearing, they're talking about how that she lacks financial means.
A specific finding relating to her employment and her ability to pay. It wasn't based on the statutory presumption. Is that right?
I think that because there was no restitution affidavit filed and the presumption, the judge had no other option to find that she had the ability.
Oh, it's different. I think it's very similar to that People versus Jackson case out of Michigan, where there's a statutory presumption of non-indigency, and then we allow the individuals an opportunity to say otherwise. Do you think that that is similar to what Iowa has done?
And I did the notice of additional authority of People v. Jackson because there's 2 parts to Jackson. And that's the second part that you're talking about, is that the presumption is in the what I like to call the garnishment section of the code in Michigan, where an inmate may have their account deducted. But the presumption in that case starts with the procedure necessary applies to only prisoners who have an apparent ability to pay. And they have the minimum, which is $50. If you have more than $50 in your account, then Michigan can deduct out of the inmate account. If you have under $50 in your account, then the presumption is not there. So here what we start with is every single criminal defendant, and let's face it, the vast majority of criminal defendants are indigent. They have a right to court-appointed counsel. They're starting with a presumption that they have the ability to pay. So we don't have this narrow class of people. We have the biggest class there is.
In fact, they had a chance to say, okay, you can presume all you want, I want to be heard on it, and they should be heard on it. Your client never asked for that, correct? Even though the document she signed talked about it?
What we have is that this court and the United States Supreme Court has said that it's not the defendant's burden. that in order to, and I think, again, Michigan, on page, and I think it's going to be in the Northwest Reporter site, 644, where the court says the ability to pay analysis should not be confused with the underlying constitutional tenet. It's merely procedural. So the tenet is that indigent persons should be not forced to pay if they have no means to do so, or it is causing a hardship.
Picture, what is unfair about placing the burden on the defendant? I mean, I understand we have sort of a complicated process and to some extent a new process, but what is unfair about putting the burden on the defendant to show her inability to pay? After all, she's got the information about her inability to pay, as opposed to requiring the state to prove that she's able to pay.
There's maybe a little distinction there, is that maybe she has a burden of persuasion to say, here's my, what I make. If you look at her financial affidavit, it was zero. She made nothing, and then she got 2 part-time jobs.
And yet then she came in at sentencing and had 2 jobs. And, well, in her financial affidavit, she's 47 years old, said no kids, didn't explain why she wasn't working. And then at sentencing, she has 2 jobs. So, I mean, if I'm the judge, I might have a question about what's going on.
The judge have a question about what's going on is proper, because the burden should be on the judge to ask these questions, and then the defendant can explain. So the other thing that's also interesting about this case is that clearly Ms. McCalley has children, because her driver's license was suspended for non-payment of child support.
In the past, it could be she owes back support. I don't know. I took the affidavit as suggesting maybe she doesn't have custody of them or physical care of them.
Why didn't she get a temporary work permit?
Shows that she was looking at the possibility of trying to get back in a payment plan. If you look at the statute for the work permit and the DOT form, a work permit does not come without additional fees and costs either. One, I think that she would have to prove that there's no other means of being able to drive to an approved designation, job, treatment, community service, and try
her to have made to the court in asking for a break on the fines and restitution. I want to touch briefly on the actual amounts. I'm looking at a document from the record, shows it was filed on December 23rd. So I'm going to assume from our rules of EDMS that lawyers of record are notified of that. The sentencing, I think, was December 8th. So this is well within 30 days. And it has the financial summary, which totals $680.54, and that includes the 2 different charges for indigent defense fund and some other things. So can't we presume that she knew the amounts within her period of time to ask for a hearing on it?
assume that someone sent it to her.
Part of EDMS that a lawyer is of record? And I'm once again, I'm back to the, is this maybe an ineffective assistance case? But my point is the record shows this evidence was there and was through our EDMS system. I think it's Rule 25. Can't the court assume if something's filed through EDMS that the parties of record have been informed?
I believe what you're looking at is in the appendix also, and that is a part of the combined general docket that's certified to this court after the notice of appeal. I think that's what you're looking at, and it's.
I meant to put for today. I can't remember which document I got it from, whether it was the pleadings bundle or the appendix, but regardless, it's an official document of this case.
Certified to the court. That would be the only document that would be part of the record to show any sort of financial judgment.
Paragraph 8 of the plea agreement, there's a very long section regarding waiver of challenges to the reasonable ability to pay. On this record, why isn't that paragraph sufficient to find waiver in this case?
Because the statute is the one that says that there's a waiver if you haven't filed it. And if the statute is not constitutional, then there cannot be a valid waiver.
On presumptions, there's all kinds of different presumptions, actually. I mean, there's absolute presumption. Clearly, that's not at stake here, in play here. There's a burden shifting presumption, and then there's kind of the bursting bubble presumption. I mean, if it was an absolute presumption, I think that would be fraught with problems. But I don't think anybody claims it is. How do you interpret the presumption? Is it a bursting bubble, so-called bursting bubble, a burden of production, or does it shift the burden? Question number one. And then question number two, what kind of presumption do you think the district court applied in this case?
If I'm going to run out of time, may I answer the question? Please do. I think it is a shifting of the burden of production, persuasion. It's shifting the burden to the defendant that that person must request the hearing to ask the court to make the determination and must prove by a preponderance of evidence that they have the inability to pay the entire amount. Does that answer your first question?
Maybe. What did the district court do here? I mean, quite frankly, I think there's a difference between shifting burden of proof and the so-called bursting bubble. The bursting bubble is the least offensive. I mean, it does require you to file a piece of paper, but the bursting bubble doesn't cut very substantially into an indigent defendant's ability to show lack of means. A shifting of the burden of proof is much more aggressive. I'm not exactly sure what happened here, frankly. The district court heard the evidence and made a determination, but help me out. Is it clear that the district court shifted the burden of proof and that was determinative here? Or did the district court find, is based on the facts, that the state has shown that restitution was appropriate?
The judge really took up restitution at all. I mean, the statute requires that the defendant has to make the request, file the affidavit, and if that doesn't happen, then the judge finds that the defendant has the ability to pay the entire amount. What the judge did with finding that she had two part-time jobs during the pandemic, both in the service industry, that no information about how much money she made from those part-time jobs, what the rest of her financial obligations were. None of that happened. What the judge was stuck with, based upon the statute, was, I have to find that you have the ability to pay everything and you have two jobs. But those two jobs are meaningless without something more along with it. I hope I answered your question, Your Honor. With that said, my time is way over, and I would ask that this be reversed and remanded for a new sentencing hearing. Thank you.
Thank you. Trout.
May it please the court. I am now Martha Trout, formerly Martha Bozen, and I represent the state. The district court didn't do anything wrong when it sentenced the defendant to 6 days in jail and ordered her to pay restitution for court costs and attorney fees. In fact, the district court complied with the provisions of 901.5 as to the sentence and the new provisions of Iowa Code Section 910.2a in ordering the defendant to pay court costs and attorney fees. Now, turning to the issue of the reasonable ability to pay, I quote from the sentencing transcript. This is the district court judge to defense counsel. Would Ms. McCalley like to address reasonable ability to pay category B costs today or reserve that for a later date? And defense counsel said, Your Honor, we can reserve that for a later date. However, no action was taken on that and the notice of appeal was filed. This is not an instance in which the district court summarily presumed that Ms. McCalley had the reasonable ability to pay.
Pursue the questions I had of your opposing counsel. What kind of presumption does the statute create? Does it really shift the burden of proof? Does it simply involve a burden of persuasion? It's not an absolute, I mean, I take it you agree, it's not an absolute presumption. Yeah.
Rebuttable presumption. It is a rebuttable presumption to the extent that the statute uses presumption. Now
Presumptions, I mean,
when you look at the types of restitution that are considered for a restitution order, you have pecuniary damages, which is the state's burden to establish. There are category A, which are the fines, penalties, and surcharges, and those are drawn from the statute. What we have here or at issue is the category B, which...
I'll just tell you straight out, if this actually shifts the burden of proof, I might have some serious problems because I think the indigent defendant under the United States Supreme Court case law should not be bearing the burden of showing indigency, I think, tentatively. But if it's merely a burden of production, of what I've characterized as a bursting bubble, it's a less aggressive presumption. And I don't think it's clear from the statute or from what the district court did in this case exactly who thought what the presumption meant. It's a variable term, and how you approach it could affect the outcome.
Well, Your Honor, I think that when we look at what has to be shown here, and essentially it's a financial affidavit, which in the civil context I think is similar to a civil judgment or debtor exam, and then be subject to cross-examination. And I think who better than the defendant to provide some information to the court?
Maybe, but I don't think, and maybe we should argue about this or at least have an exchange of views. I doubt that it would be proper to impose a burden of proof on the defendant to show indigency under the cases. I mean, it seems to me the state has got that burden. Now, if the indigent defendant chooses not to avail himself of a potential remedy and takes a pass, and that's a different matter. But I at least would have some question if the burden of proof is actually shifted. I mean, we don't shift the burden of proof in a criminal defense. I mean, we don't say, well, a defendant has a burden of proof in X, Y, and Z. Might have the burden of production. Justice Mansfield's point in part, I think, is that, well, I mean, what's wrong with saying that the defendant ought to come forward with a financial affidavit and so forth? And that's a fairly comparatively mild provision. But if you actually shift the burden of proof, then I think you're in a completely different ballgame.
Because I think what our case law says is that rebuttable presumptions are constitutional, first and foremost. And also, in this particular circumstance, the defendant did have an opportunity to provide some indication. When you're talking about defenses, the state has to prove its case. The defendant is allowed to assert a defense. The state is then given an opportunity to rebut that. So I don't think that in that context we're talking about similar things. But what your question did raise a question with me was, well, what about applications for indigent defense? I mean, is that a burden? We do that uniformly when we have applications for counsel.
We're on that subject. I mean, if Ms. McCalley had been sentenced like at that marble palace that's going up on the river, she wouldn't have to repay her attorney fees, right? Because the feds don't charge you. I mean, if free attorney is free, it really is. Not in the state system where you get charged back for it unless you can demonstrate you can't pay for it.
Function that we have, that the legislature has deemed that and I can't recall what it was prior to 1982, there were parts of what are restitution that a defendant did not have to repay. I can't remember if it's costs or if it was attorney fees. But since that time, we now require the reimbursement. And we want to require reimbursement for a couple of reasons. Number one, our purposes of restitution are twofold, and that is to instill responsibility in the offender. What better reason than to have the offender take responsibility for his or her action and pay for the cost of the prosecution?
I think, but
Also, and I apologize if I interrupt you, Your Honor, but there's also a portion that these funds are coming from indigent defense. That is a revolving fund that allows for indigent defendants across the state to have counsel and to refill those coffers so that the next person can do that. The requirement that a person repay costs and fees is within the context of restitution civil. There is a case, State versus Slider, that Ms. Lucey handled, and it deals with whether or not a defendant can be held in contempt for non-payment of costs and fees. And this court said, no, it is civil. The repayment of costs and fees is civil, and absent any ability to hold that defendant in contempt under Chapter 910, we are not going to allow the state to hold this person in contempt absent the same type of defenses or exemptions that existed in the civil context. So we're treating those as civil. I mean, the court has found that those types of damages are civil. It is not punishment, and therefore, to the extent that there is a presumption, that presumption is, it's not overbearing on this defendant in any way. It's at some point, this defendant, a criminal, a person who has violated the statute multiple times, has to come to terms with the fact that she's got to do something to.
Sort of on that point, I think the argument's being made that there's some willful non-payment here, and if I didn't see that in this record. In fact, the record seemed to be that we don't really know much about whether she can pay or can't pay. She didn't put on evidence of it. So where is that here? Why should we find that the district court properly imposed a jail term instead of a fine based upon some willful failure?
Willfulness goes to the first issue on sentencing and the fact of her recidivism, that going back to 2015 when she lost her license due to non-payment of child support, and then actually the child support was in 2015, and then subsequently it was the loss of her license. Going on from that, it was nothing would curtail her illegal behavior. And so I think that's the willfulness goes to that.
Okay, I get that argument that fines didn't stop her yet, but where is it in this record that she had funds to pay and didn't pay?
Well, Your Honor, the fact that the willfulness goes to the fact that she was, I think that at this point in this record, she had 2 jobs and that she wasn't making any payments. And that the court could infer, I don't necessarily think that this court found that there was so much willfulness prior to it. I think that the court based it on the fact that she could pay the court costs and fees based upon the fact that she had 2 jobs and that nothing else was presented.
Or the justification by the judge also, and you keep driving. It's not just a matter of you aren't paying your fines, and you keep driving. But I want to redirect your attention to something about, do you believe, if you could answer this quick question, then I've got one more follow-up. Do you think the changes in the statute were procedural or substantive on the new?
Procedural, Your Honor, and I believe that even the defense admits it on page 48 of her brief when she says it was a change in the process. And
if we were, and I guess another lead-in question, did the defendant receive notice of the amounts we're talking about?
to my knowledge, If we can rely on EDMS, if those amounts were put forth, yes.
Need to reverse and remand if she did not have an opportunity to know the appropriate amount of restitution. If we can't find that there was notice, how do you suggest we resolve that?
I think at some point, that needs to be raised before appellate argument nearly a year after the sentence was handed down. And
Related question. Are any of these issues actually before us with respect to challenging the statute, given the waiver provision in paragraph 8 of the plea agreement, counsel's statement at sentencing that they did not want the reasonable ability to pay issue addressed at that time, and then you have an independent finding of ability to pay based on her employment? It's not clear to me why we need to address any of the statutory issues in this case.
I did touch upon the waiver in my brief, and I agree that 910.2a allows for an appeal from the judgment and sentence. However, there isn't anything for this court to review because it has been waived. It was waived I didn't catch that in the plea, but certainly by her decision not to discuss it at the sentencing. I think that provision waiving, subsequent to that, filing the notice of appeal which would have extinguished any jurisdiction in the district court.
Say something about you can contest it later?
Yes, but she didn't do that. She would have had 30 days. Within the statute allows for you contest it at sentencing or within 30 days.
Interpretation is under 910.7. You can contest both the overall amount and how much you have to pay a month.
You're limited. 910.2a allows you to challenge the reasonable ability to pay. 910.7 picks up, it doesn't act retroactively. It will allow a defendant at any time during the period of probation, incarceration, or parole to challenge the underlying restitution. Those are different things. And so that you can't go back and use a 910.7 to suddenly correct what you believe was wrong at sentencing.
I want to understand that. So the state's view is you can't use, let's say at sentencing you had ability to pay X and then your financial circumstances deteriorate, but you're still on probation, parole, sentence. You're not allowed under 910.7 to go in and say, I want, instead of having to repay $5,000, I only am able to repay $2,500 total. You can't do that?
The statute does not provide for any means to challenge the reasonable ability to pay the original order. Coming to 910.7, if there has been a change in circumstances, you can seek to have a modification of that amount of restitution, but it is not retroactive to the original sentence. It's only as a result of what your change in circumstances is. If there are no further questions, the state respectfully requests that this court affirm the district court sentence.
I'd like to address a couple things that Ms. Trout, which now I'll call her by the right name, she compared this case to Mr. Slider. She's correct. Slider was my case. Mr. Slider was acquitted. He had a civil judgment. He did not have criminal restitution. Same as Mr. Dudley. He did not have criminal restitution. He was acquitted. There is a distinction, whether it is a civil judgment or it is part of criminal restitution, which is part of sentencing, which is punishment. If you look at what some of the federal cases, when they're starting to talk about and look at restitution, and I believe, Justice Mansfield, you mentioned this in the Davison case, I don't know, last month, 2 months ago, whatever it was, that there is some dissent in the U.S. Supreme Court whether restitution should have a jury trial and a separate finding because it's punishment. And that's victim restitution. That's not even, that's not even costs paid to the government. There was no recoupment of attorney fees or, and I want to almost say cost too, but I'm not 100% sure of that, at common law. This is a statutory enactment.
Question. If the state had the burden to prove or production on the defendant's financial status at the time of sentencing, how would the state go about collecting that evidence?
If the state, and what I'm saying, and again, maybe this isn't going to be a popular opinion, I believe that the burden is on the court to make that determination, and that
Court have available to determine the defendant's financial status at the time of sentencing?
if it changes from what has happened where the defendant needs to be able to provide information that may be different from the financial affidavit that has been filed. Here we know that she had 0 jobs at that time. But, you know, the judge didn't say, how much money do you make at your part-time jobs? What is the hours that you make? You know, how many hours are you working? Are you making, you know, however much waiters and waitresses make? And then
I don't want to answer that. Then what does the judge do at that point at sentencing?
find that there is the ability to pay then.
How is that different than this statute where, in the absence of information, the judge says, I find you have the ability to pay until you provide me with some financial information that shows to the contrary? It's the exact same fact pattern.
The idea that the court starts with an indigent defendant, that they do not have the ability to pay because they would not qualify for court-appointed counsel.
Judge do the same thing. You're saying he didn't come right out and say, what's your rent? What do you pay for groceries a month? But he did say, Ms. Sparks, would your client, Ms. McCalley, like to address reasonable ability to pay Category B costs today or reserve that for later? Isn't that a huge, obvious, open invitation? Let's talk numbers. Let's talk shop. And your client said, no.
I think that on this cold written record, it's really difficult to say if it was an open invitation or if it was, do you have a financial? Are we doing that today? You know, to interpret that the court really wanted to go deep into her financial background at this stage after he just found that she had no money. And then, you know, the court then goes on to say that I find that she has a reasonable ability to pay.
I still don't read the transcript that way, that the district court was finding that she had no money. That argument was being made by you know, the lawyers in the courtroom, but what I see the judge saying, and I think I'm following up maybe on the chief's suggestion, is the fines have not been effective at getting her to stop driving under suspension, and therefore we're going to try something different. I don't read him as saying that she has no ability to pay, just that she's not paying the fines, so let's try something different.
Between page 7 and 8, you know, the court finds that, you know, the purposes of probation for rehabilitation would be made. And it's the question of her non-payment of fines, child support, that led to her suspension. Probation would incur additional costs, economic.
Before he talked about that, he said the court considers the purposes of disposition to rehabilitate defendant and prevent further offenses from her driving.
And we're looking at this idea that if she had money, that would deter her. But since she doesn't have money, I guess she'll go to jail.
Sentence. Probation would incur additional economic impact to her, that's true. But then in the very same sentence, the court goes on, and I think on this sort of offense, offer her very little in terms of rehabilitative efforts or protection of the community. And that is not a financial consideration. That's simply pointing out in the second part of the sentence that the fines haven't gotten her to stop, right?
Gotten her to stop because she doesn't have any money to pay. To get money to pay, she needs to work. I won't go into the whole cycle of poverty here. But what we have is that if we're not looking at rehabilitating her or protecting society, we're sending her to jail. Why? Because she doesn't have money to pay the fine that would maybe deter others. So the option is, if you had money, we wouldn't send you to jail. And as I point out in the brief, there are means of suspending probation fees. I don't know how often that happens, but there is. There are other options for someone who lacks financial means than saying, you commit a crime, you're going to go to jail because you don't have any money. And I'm counting up again, Chief, and I will wrap up, and I would ask that Ms. McCalley's sentence be vacated, that you find that this change in statute is unconstitutional by this court's precedent and U.S. Supreme Court precedents. Thank you.
Martha Lucey and Martha Trout. The two Lucys are now dismissed. Thank you. Just a couple-minute recess here while we allow attorneys to change places. The next case is McGrew versus Odo Odesi.